To succeed on a claim of ineffective assistance of counsel, a convicted defendant must meet the two-pronged test established in Strickland v. Washington. This involves showing that his or her attorney's performance fell below an objective standard of reasonableness, and there's a reasonable probability that if the attorney had performed competently, the defendant's trial would have had a different outcome. In Glover v. United States, the Supreme Court considered whether an arguably small increase in a defendant's prison sentence can satisfy the second prong of the Strickland test. Paul Glover was the vice president and general counsel of a Chicago union. He used his position to arrange kickbacks for himself and a group of co-conspirators. As a result, Glover was convicted of labor racketeering, money laundering, and tax evasion. The pre-sentence report identified these offenses as counts involving substantially the same harm under the federal sentencing guidelines and recommended that they be grouped together. The government objected, arguing that Glover's money laundering counts shouldn't be grouped with the other counts. Glover's attorneys didn't contest the government's argument. The court agreed with the government's no-grouping argument, and as a result, Glover was sentenced to 84 months in prison. This sentence was between 6 and 21 months longer than the sentence Glover would have received if all the counts had been grouped. On appeal, Glover's attorneys failed to raise the grouping issue, and the Seventh Circuit affirmed his sentence. Glover filed a pro se motion to correct his sentence, arguing that his attorney's failure to address the grouping issue constituted ineffective assistance of counsel. The district court denied Glover's motion, reasoning that an increase in a defendant's sentence can only be prejudicial if it's substantial. The court concluded that a 6 to 21-month sentence increase wasn't significant enough to qualify as prejudice under Strickland. The Seventh Circuit affirmed, and the United States Supreme Court granted cert.